Shenkman. I'm joined by my friend and colleague, Bob Keebler. And we're going to do a program that I think is really important, really practical. Bob, until you suggested this, I've not actually seen that much being done specifically on the CPA's role in asset protection planning. And while certainly the comments may be helpful to financial advisors, attorneys, and other estate planners, we're going to try to take this from the lens of the CPA. And who better to do that with than Mr. Keebler, right?
Good day, Marty, and thank you for inviting me to join you today.
So let's get started first. Let me make a few general comments about asset protection. First of all, almost every single client needs this. This is not only for surgeons or people with unusually high risk professions. We live in the most incredibly litigious society. In the New York area where I live, the biggest radio station, it seems like half or more of the ads are for litigation attorneys looking for suits and claims. Our clients are the ones that face this. And it's not only creating some complex trust, there's a lot of practical planning, and a lot of it, and I think this is what was behind your motivation for the program, Bob, is squarely within the realm of what CPAs are best at as compared to every other advisor. How would you introduce this? Because our goal with the introduction is to motivate CPAs to understand that this should be part and parcel of what they do for most of their clients.
Well, I think it's a byproduct of any type of holistic advice. And clearly the specific advice of what you do, how you put together a particular asset protection trust is going to be in the lawyer's province. That no one is going to argue that. But Marty, I'll give you a couple examples. Somebody comes to see me, and going to the extreme, they have, a top 10% dangerous business, and we find out that they run as a proprietorship. Clearly, the CPA needs to say, wait a minute, we need to talk to your lawyer about wrapping this in an LLC or a corporation. We need to do something to protect you. And other things go along with that too. For example, a physician, call her a neurosurgeon, is retiring, and she has $8 million in her qualified plan. She lives with other doctors. She lives in a state where IRA protection is not great, and she's asking, well, do I roll my money from my ERISA plan to an IRA? And the answer is no. No, not until your regular malpractice attorney tells you you've run the statute of limitations.
Bob, let's just clarify what you said, because it's a really important point. An ERISA plan is protected under federal law from creditors and claimants. If you roll over into an IRA, and if you Roth that IRA, you convert it, the IRA and the Roth IRA are not protected under federal statute, but under state law. So before you counsel a client that has a qualified ERISA plan that is protected, to roll it over, and from a simplicity standpoint, rolling it over is certainly the answer. But are they undermining the level of asset protection they have? And that's an issue CPAs see a lot, because CPAs are I would think, a primary phone call when a client's thinking of retiring or rolling over assets. And I'm also concerned that if they call their financial advisor, will the financial advisor have the understanding to raise the question, hey, check with your attorney and see how this IRA will be protected under state law before you do anything. Really important.
And that's just one of the basic things. So you have to ask yourself, do we have the right entities? Have we compartmentalized our risk? Marty, if you were helping somebody with 25 apartment buildings and they were all in one LLC, you'd probably say, hey, can we break these up into 5 apartment buildings per LLC, or at the extreme, 1 apartment building per LLC. And
I wouldn't even use the word extreme. I think that's the gold standard, to have a separate entity for each property or each business risk. And we're going to talk about this again in the balance sheet analysis in a minute. What I've done for that, Bob, is I've said, okay, what are the values of all these different properties? And what we've done is anything that's really valuable and what's defined as really will vary by client, right? We'll put those in a separate entity. You have a couple of small little pieces of property or business endeavors that don't have a lot of value, maybe we'll group those in a single LLC.
Well, that's exactly correct. And the CPA is going to see this when they're doing the tax return, A, and B, Marty, they're going to be able to say to the client and the client's lawyer, if we do these as 100% owned entities, they are disregarded for tax purposes. We're not going to create an onerous burden for tax purposes. And that's the key. That's often what stops people. But if you have single member LLCs, it's no big deal.
Let's talk about that for a second too. And I want to ask you before, I want to talk about the benefits of regarded versus disregarded. But what about the unauthorized practice law? Do you think some CPAs are saying, well, you know, I can't really tell a client they should be having entities own their business or their rental properties because that's unauthorized practice of law? I wouldn't think that it's an issue at all. You're not telling them which type of entity or how to form it or what to do. And I have seen CPAs do that. I don't know that I would go that far, but having the discussion of why you need an entity and that you need separate entities, I don't see that as the unauthorized practice of law. Do you?
No, that's not the unauthorized practice law. And you're much like with estate planning, just pure estate planning, if you're doing it hand in hand with the client's lawyer, you're not going to have a problem. It's when I've seen this too. I've seen it with non-CPAs more than with CPAs, but they put together entities and they incorporate businesses, and that's just something the lawyer should do, period. It's not even a discussion point.
I think more worrisome than the risk of unauthorized practice of law for a CPA that's forming an entity. What if you're really not doing it right? The liability of having the wrong entity and it being pierced or not accomplishing its goal, that's a problem. You should be integrally involved in the idea, the planning, bringing it up. You can be the catalyst for the planning. You can be the core of the decision making about the type of entity from a tax perspective, but I don't think I'd form an entity or dissolve an entity as a CPA. One of the things I had recently with a client is they needed to set up a new LLC for a certain business matter. And I don't know why, but he talked to his accountant before he talked to me. And the accountant told him to go, I don't want to mention the name, but to one of the online services that forms it. The online service charged my client more money than the corporate filing service that we use as an attorney. The entity was set up in the wrong jurisdiction and it wasn't structured properly. So it was a disaster from every perspective and cost him more. And in the end, what the client did at my advice was he dissolved the entity and we formed a new entity and did it properly. So be involved, just no reasonable limits with what you do. Bob, let's let me talk about this sort of continuum concept because I think this is really important. I think a lot of people misperceive what asset protection planning is, and they think asset protection, and you kind of said it, so I don't mean to pick on you, but you know, it's an asset protection trust. Asset protection is a whole continuum of steps. If a client comes into your office, a great conversation starter is, hey, do you have an excess personal liability or umbrella insurance policy? It shocks me how many people don't have a policy or, you know, may have a 10 or 20 or $50 million net worth and they got $1 million limit policy because that's just what somebody sold them. Talking about basic insurance coverage, that's part of asset protection. It may be on this end of the spectrum, right? Not this end, but it's all part of what needs to be done. A step beyond, you know, the basics of insurance coverage is entity formation. A step beyond that may be having trusts. A step beyond that is trust with tiers of entities. But it's a continuum. And you only have to go as far as you as a practitioner are comfortable. But every client needs something. I mean, no client shouldn't have proper insurance. Do you have a kid? You know, is the kid driving your car? Why don't you give the kid the car and let them have the liability?
These are all great points, Marty. And I think a CPA can have a checklist. If you're failing those points, then you refer them back to the insurance advisors or to the legal advisors.
So it is a continuum. And the reason I want to stress that is you don't have to go to the nth degree. There's always steps to do. And it's not, oh, you need an expensive trust in Nevada or overseas in the Cook Islands. Lots of clients will do better, just the simple things we've just said. They'll be in better shape, having proper insurance coverage with enough, on the high end, not the low end. I've seen a lot of people have low deductibles when they should in fact have a high deductible because they're not going to file a claim for a couple of grand. Maybe they need a 5 or 10 or higher $1,000 deductible, but they need millions more of overall coverage because the risk to the client isn't losing the 5 grand on the low end. It's getting sued for 10 million when they only have 3 million of coverage. And by the way, some clients have the misconception, and I've seen this with doctors frequently. Hopefully it's changing, but I still hear it. Oh, I have X millions of dollars of coverage. No one's going to sue me for more than that. Of course they will. Especially if a litigator is getting a contingent fee, they're going to sue us for as much as they can, and the clients are going to want them, the plaintiffs, to do that. And what they're going to do is if the settlement's beyond your insurance coverage, they're going after personal assets. That's why you need asset protection, and that's why clients need higher limits on their insurance. And maybe if they get higher deductibles, it's not going to cost all that much more. So keep in mind that it's a full continuum, and you can move with clients as appropriate for the client and as appropriate for your comfort level, as far down that continuum as you feel is appropriate based on your knowledge and the client's situation. Bob, one of the things, our next point, and I'll let you go first, and I believe it as well, CPAs are unique amongst all the advisors in certain aspects of asset protection planning where they can make a contribution to that to the client. Why don't you talk about that, and if I have anything to add when you're done, I will.
Well, I think the CPAs across the country see their clients all the time, okay? And they understand their business, they understand the entities they have, and they can identify that Achilles heel. And it's not that hard, Marty. If, again, a gentleman is a real estate tycoon, 50 buildings in one LLC, that's ridiculous. And you'd identify that, have that conversation. The insurance, it's every time somebody comes to see me for estate planning, I ask them what their umbrella policy looks like. And then I typically send them back to their insurance agent to have that discussion. I won't give them, I'm very careful. I've never told anybody how much to buy because I don't want them to be sued for 10 million when I told them to buy 5, right? But that's something that their agent should tell them. And if their agent tells them that and that it's wrong, it's arguably under the agent's errors and omissions policy. So these are all things that we try to do. And things like IRAs, that person leaving an ERISA plan, going into an IRA, of course the CPA is going to know that. If you have a doc with 10 million in her plan and she's retiring, you got to say, hey, just so you understand, you lose some of your asset protection when you leave the comfort of that ERISA plan. Now, that's going to vary state to state, and it's complex. It depends. An ERISA, you have an ERISA plan, you have an IRA in bankruptcy, and then you have an IRA without bankruptcy. And again, varies state to state. But what we do know, Marty, is if you're in that ERISA plan, you're golden.
I think some of the reasons that CPAs have really an incredible role to play in asset protection, and there's not enough of it done, and I don't see enough CPAs being as proactive as they should. You get a whole view of the client's financial picture. If you're doing the entity returns, the S-corp returns, the partnership returns, the trust returns, the personal return, you have an understanding of the weeds, the details of a lot of their planning that no other advisor may even begin to understand. CPAs are trained to understand what numbers are, what budgets are, what expenditures are. You know if a client, when you're doing the 1120S and the client's got, is paying for their kids' cars on the corporate return, you're going to pick that up. It's not just about, gee golly, they're pushing the envelope to get a tax deduction. I mean, it shouldn't be done. But think about it from a creditor protection perspective. If a client is excessively charging personal expenses on an entity and a creditor sues, the creditor, when they find that out, is going to say, hey, Your Honor, these folks ignored the formalities of the entity. They commingled personal and business expenses on the business. They've disrespected the corporate form. I want to be able to pierce through that 1120S and get the valuable building, business, assets, whatever's inside that company I want to get. And I don't think any other advisor is going to have that lens to see that. I, as a lawyer, may see entity documents. I may know about the trust that owns the entity. I'm not going to see inside of what they're actually spending on and deducting it. But you're putting together a tax return. You're looking at, whether it's QuickBooks or Quicken or whatever they're using for the paperwork, or you may even be doing some kind of report for a lender. You know what they're doing. To not address asset protection is missing an opportunity to be a real value add to the client. And one of the things to say is, listen, I know you like deducting your kids' cars on the business, but if the kid gets in an accident and your insurance is voided because it's not a legitimate business, you're putting your whole business at risk to get a how much of a deduction? And if you get sued, you're putting your whole business in jeopardy because they may pierce the entity. Bob, thoughts on that?
No, I think that's right. And for example, if you represented a person that owned 50 franchises, Burger King, McDonald's, something like that, the ideal planning would be 50 LLCs for the operations and 50 LLCs for the buildings.
Right.
And you create a lot of good asset protection there. That's just rock solid thinking. And Marty, you kind of alluded to it, but for the CPAs listening, do not underestimate the ability of the insurance company to find a way out of coverage, okay? I mean, it's legendary what they do. And that's why you can't just blindly depend on the insurance. That's your first line of defense, but you need to go beyond that.
Vitally important. Get the insurance in place, get a good insurance consultant, make sure they have adequate upper liability limits. Ask questions with the client because the client may not realize it. You may know that the client's on a board of directors. Well, is it a charitable board? Is it covered by their homeowner's excess liability? Is it not covered? Do they need a supplemental E&O policy on their own? Does the charity have one? Does the board have one? Just the nature of what we do when we were trained as accountants is to be skeptical, to ask questions, and to analyze things. That nature is essential to asset protection because a lot of the good steps that are to be taken are not, the complex sophistication of how do I structure a domestic asset protection trust. That may be important too, but a lot of the basics are just, I don't know if I should use common sense because a lot of clients are not going to have the knowledge, but with the training you have as a CPA, you can ask a lot of questions, whether it's the insurance, the corporate attorney, the entity, the expenses that they're deducting inappropriately. There's lots of things for you to question, and you can help the client understand you're jeopardizing everything to get a tax deduction of how much, or you're saving how much on your insurance in order to not have enough a limit that doesn't make sense. And I agree with Bob. I can't tell somebody you need X dollars of coverage. I may say you're worth 5 million. How can you not at least have 5 million of coverage? That's not a maximum. It's almost a minimum. But even 5 million of coverage may not be enough because if there's a $10 million claim, the 5 million is satisfied from the insurance, and the other 5 million wipes out a large part of their net worth. So I think it's important to ask a lot of questions and to realize if you haven't done asset protection planning, it is within your purview to do an awful lot to help. You have a deep knowledge of the interrelationship of all their different matters. If there's multiple entities, like Bob has mentioned, ideally you have the real estate in one entity and the operating company in another. Well, there has to be a lease between them. A rent should be paid. Is there? How many clients with related parties, Bob, do you see that don't have the contractual arrangements in writing that they're supposed to have?
We want leases, and those leases should be drafted by their lawyer, by their business lawyer.
And there should be some common sense, some reasonableness to what the rent is. And, if the rent can go from here to here, maybe for tax reasons you want to be here, but, maybe you get a real estate broker to give you a letter, or maybe you go online and do some research so you have something to show that it wasn't just totally arbitrary. If the rent can be from, $10,000 a month and they're charging $2,000, does that undermine the viability of an independent lease? If it's could be 10,000 and it's 7,500 because they want to pay a little less to keep more in the other entity, that may be fine, but it should be within reason. And a lot of times it's not. And oh, by the way, are they actually paying the rent? You know that. Are they paying the interest on notes when there's a family loan? If a loan has no interest paid, Bob, is the IRS going to respect it?
Well, of course not. No,
Nor will the creditors.
Right. And CPAs will pick up on that when they're doing the tax returns. They're going to see that, well, there's a loan at 10 million, but no interest. Come on, we can't have that. Because the other thing that can happen, Marty, as long as we're here, you get into this debt versus equity issue. Most of us view that as a tax issue under Section 385, but it's also a creditor issue. If I have a business worth $10 million and I have 10 million of equity in there, obviously that 10 million of equity is at risk. But if I have, let's say, 4 million of equity and 6 million of debt, and the debt is secured properly, just like a bank would secure it, if we dotted our I's and crossed our T's, there's a pretty good argument that if the business fails, I have a security interest in that. My creditors will stand behind that security interest. And that's real critical. So CPAs are going to see if the debt to equity ratio is 100 to 1, no court in this country is going to respect that debt, inside debt from the founder. But on the other hand, if it's a reasonable debt to equity ratio, the court will respect that.
I think that's a really important point. And for practitioners, CPAs that are feeling uncomfortable expanding into or doing more asset protection, you have the training. As Bob just pointed out, and it's not perhaps a perfect correlation, but if something's not going to be respected by the IRS, and you understand that from the training and the work you do as a CPA, a creditor is probably not going to have to respect it either. A court, when challenged in a claim, may overturn it as well. So if something doesn't pass the smell test from a tax perspective, which you know very well, it probably won't pass muster from an asset protection perspective.
I think that's absolutely correct.
So Bob, one of the practical issues that concerns me for CPAs is, this client is only letting me charge X dollars to do an 1120S. I get what you're saying. I see things that don't make sense, but I'm barely getting paid enough to do the tax return and crank it out. Can I take an extra half an hour and, summarize a memo, dictate a letter to the client about some of the issues you're talking about? The client's not even paying me for the return. Thoughts, practical thoughts, please.
You just have to get it into a separate engagement, Marty.
Keep talking. Tell people what to do because they need to. Well, they should, for the client's sake.
I think you make a list of points. You bring them up very quickly with the client, 5-10 minutes of ideas, and you say, we should really focus on this, because if something goes sideways, if something goes wrong, I want you to be able to survive that.
I think that may be a practical solution. I would be careful how I say it, but if you're looking at an 1120S and you're giving comments to the client, you may be doing this anyhow, right? Like, you didn't pay interest on the loan. Be aware that from a tax perspective, the IRS may not respect it. You got to pay interest regularly. You have personal expenses. We gotta. Forgive me if I'm misspeaking. We got to treat them as a loan. You got to repay it. You can't have certain personal expenses on the business. And then go on and say, although you've only engaged me to address the income tax return, you should keep in mind that the above comments also may jeopardize the asset protection benefits, which is the sole reason you formed the corporation. No one forms an entity. I mean, the primary reason most entities are formed is asset protection. Go on writing and say it. Just say, I'm not giving you a thorough analysis. I'm just commenting. Bob, how would you refine what I just babbled about?
No, I think that's right. You identify the risk and you work with the client and the lawyer to come up with a solution. Most of the time, the solution's pretty straightforward.
But I don't think anyone but the CPA will see these things. As a lawyer, I may see the entity documents. I don't know after I set up an entity whether the client's respecting the form of the entity, if I did a loan agreement, whether they're actually paying interest. I have no idea what personal expenses they're doing that could undermine it. That's really important. And CPAs are probably the only advisor that has the window, the lens to see those things.
Yeah, and a lot of this is tax driven because, so I represented a gentleman, to make a long story short, the business has been in his family since before the Civil War. And they had somewhat like 35 million of securities sitting next to all these risky endeavors on businesses that, operated on the Great Lakes. And we did this reorganization to create a holding company, Marty, where we got all those securities up to a holding company level, got all the risk down below in 6 or 7 different entities. And that was just a wonderful project. And basically, tremendously compartmentalized his risk and moved those securities out of harm's way. I mean, they were arguably up at a holding company level, and the lawyers felt that if there was litigation down below, that would be bulkheaded, if you will.
Contained within those lower tier entities.
Contained in the lower tier entities.
But critical for that, they have to have a governing document for each entity. I would do annual consents or minutes depending on the nature of the entity so that you're showing respect for the entities. I'd make sure every entity has a bank account. And I don't think the things that I just said are foreign or unusual or complex for any CPA. You may not want to do the minutes, have the lawyer do the minutes, that's fine, but ask the question. Ask the question. You see the client at minimum once a year to do a tax return, maybe quarterly to do write-ups or bank documentation. You have the window into that the lawyer is not going to know about. So if you don't blow the whistle, nobody really will be. Bob, let's make a couple quick comments on the pieces of this slide that we haven't looked at. Litigation is rising. We didn't bother getting you statistics. I mean, I think that's about as obvious as the sky is blue. Malpractice risks are growing. And oh, by the way, Bob, one of the highest risk professions is estate planning, right? I always kind of say it in jest, but it's really true. It's like every kid feels they're going to inherit 150% of what mom has. I mean, there's a lot of unreasonable expectations. A lot of advisors get caught in the crosshairs when stuff blows up in a family. Malpractice is a risk. We all should not only worry about our surgeon clients, we should worry about ourselves and use ourselves as patients for this kind of planning. Family law issues we all know about. One of the areas, and maybe you want to comment, that people raise issues with is all the estate planning changes ownership of assets. And if there's a later divorce, it's going to have a potentially significant and potentially very negative impact on one or both of the parties. That's another issue to be aware of. Bob, do you want to comment on that at all?
Well, I think when we view asset protection, it's always this outside force coming in, taking our clients' money, but also the statistics are that your biggest creditor is your spouse. So part of what a CPA can do when a person is getting married is make sure that they get that prenup in place and then help them respect the prenup. So Marty, if the prenup says what's mine is mine, what's my wife's is hers, and my CPA sees I'm starting to commingle, he or she has to say, stop. We need to keep this separate. Otherwise, if you get a divorce, the court's just going to throw up their hands and say, we can't possibly figure out who owned what. You've commingled everything.
And that's all part of appropriate asset protection planning. I'll give you a silly example that I see all the time. It's frequent. Couple gets married. One spouse, say wife, has $3 million of investment accounts that she's accumulated before the marriage or from inheritance, whatever, and it's not in a trust, so it's not protected. And in the prenuptial agreement, they come to an agreement that $3 million will always remain her separate property, but the income earned on it will be marital property. 5 years, 10 years later, how do you have any idea what's the principal and what's the income? It's a mess, and you end up having to bring a forensic accountant in to dissect what happened there. It'd be much easier to structure the account where you have a joint checking account at the same firm where the wife's premarital or separate property assets are, and you have the dividends and the interest on the bond payments paid monthly from that account into the joint checking account for the couple, so there's nothing to dissect later. And by the way, and this is something again that CPAs would understand and have reason to be involved in, is there a definition of what is income? Is income including capital gains? Is it not including capital gains? What about appreciation? These are all great roles that we as CPAs can play in helping clients address asset protection planning. I think we've talked about enterprise stuff. Bob, can you talk for a couple minutes about things to look at and that a CPA may want to do before somebody engages in any asset transfers? And I'll be right back while you start that, okay?
Sure, of course. So what we would do is typically we're going to set up a nice clean balance sheet. Okay, we're going to get everything laid out. We want to understand basically what business assets are there, what individual assets are there, and then identify where the client perceives from their business knowledge their risk, okay? And you can have the lawyer go through and see if there's any outstanding litigation against the client. That's something that you pretty much do if you put together a balance sheet anyway. Then test for solvency. Very common with real estate people. I've seen people with 100 million of real estate, but 100 million of debt. They have no real solvency. What does liquidity look like? And then you get into this concept of you have to be careful. Fraudulent transfers. Marty can talk about this more, but I cannot make a transfer that puts me in an insolvent position. Okay, so we want to be very thoughtful on that. When you're doing this, sometimes on engagement letter considerations, the lawyer is going to hire you under a Covell privilege. Sometimes that's good, sometimes not so good, but the lawyer may want to do that. That way, you're giving the lawyer knowledge, you're sharing your knowledge with the lawyer so the lawyer can provide legal advice.
Just keep in mind with Covell, and it's not that long of a case. If you haven't read it recently and you're getting retained, read it. Lawyers sometimes over broadly view what a Covell arrangement can cover. So if you are interpreting a partnership income tax return to help a lawyer understand what it means for a particular endeavor that the lawyer or matter the lawyer is pursuing, that may well make sense under a Covell because the lawyer needs your income tax insight to interpret what the return means. On the other hand, preparing a return, doing a forecast may have nothing to do, depending on the circumstances, what the lawyer is doing. Keep in mind to define the Covell arrangement specifically enough so it's clear what it is and how it ties in to what the lawyer is doing and how you're helping the lawyer. And if you're doing other tasks for the client, get a separate, unrelated, independent engagement letter that isn't mixing the Covell protected stuff with the non-Covell protected stuff.
I think that's well put. Let's jump up to the next slide, Marty.
Hang on one second. One of the things, I know you mentioned preparing a balance sheet. I think that's really vital. If somebody's going to make large asset transfers to trusts or entities, having some forecasts or modeling done, if you feel comfortable doing it, sometimes the wealth advisors do it, but if you're capable of doing it, it's really important to show that the client has enough money to meet their living expenses after these transfers. And that can be very helpful to deflect a challenge that the whatever was done was a fraudulent conveyance. No, look, here's the projections from my accountant showing that we have plenty of money to live on from our income. We didn't need it. When that's being done, one of the things that we've started to do routinely, and I'll plug our colleague Alan Gassman has a software product called Estate View, and there's a button to do a background check on somebody. Now I can go into AI and do my own background check, but he's created the whole long detailed, very detailed prompts and refines them all the time about what to do and how to format it. With a click of a button in 5 minutes of time, you can get an incredibly detailed background analysis on a particular client. I had a prospect call me recently, and this is good for your own asset protection. I had a prospect call me recently and asked about asset protection. When people call and the first words out of their mouth are asset protection, I like to know what happened, what's going on. And no, nothing. It's just, some event happened years ago and nothing's ever become of it. I just want to be cautious. That sounds reasonable. Okay, let's talk. If it's even better, nothing's happened at all, I just want to be cautious for the future, that's even better still. But I did a background check on this individual and they'd already been sued, and it came up on the background check. I wasn't comfortable proceeding because I don't want to help move any assets if there's already lawsuits in progress. But what I was really uncomfortable about, even more than that, is the prospect lied to me about the status of what was going on. I don't want to represent a client in asset protection work when they're lying to me. So getting background information can be helpful. Now think of it from the client's perspective. If you get a detailed background analysis and stick it in your file and nothing untoward is identified, that, along with the balance sheet and a financial forecast and maybe an insurance review to show that the client has appropriate insurance coverage, helps support that this is not an unreasonable transfer that's being contemplated. It's wonderful having a well-done, irrevocable trust that can provide asset protection, but it's even better if you backstop through all the things that we just mentioned, the client's security in entering into the transaction. Let me change the slide, Bob. There you go. You want to take the first shot?
Sure. So there's some very low cost things we can do. That always starts with insurance. Okay, so we know it's going to start with insurance. Then you have titling strategies, and it's important for you to work with your lawyer friends on this and make sure you understand. But in some states, Florida might be an example. Alan Gassman talks about this. There's a concept called tenancy by the entirety. And if I have something with my wife, tenancy by the entirety, and we bought it together, if I'm sued, that cannot be taken away from my wife and I. Okay. Now, other states like Texas and Florida give you unlimited homestead protection. So Marty, you read about this, but people, they'll have a $10 million net worth, but they'll have a $6 million home. And because that's protected from the claims of their creditors. Now, you put it in yellow here, so I think it's important. Where CPAs can be really important is for entities to be respected. They have to dot I's and cross T's. And Marty came up with the term trust hygiene. In other words, if I have LLCs, do they all have checking accounts? If I have 20 different restaurants and they're all in separate LLCs, do they keep separate books? Are we respecting these entities? Do we represent to the world that this is, Johnson Burger King 1, Johnson Burger King 2? And those are very important things, and CPAs are going to see that. Now, intermediate measures, LLCs, we know that. We want to wrap entities with an LLC or LLP or a S Corp. And see, the choice of those entities, there's certainly a big legal element to that, but there's also some tax issues. And very often what we see is the lawyers will collaborate with you and say, hey, we need an asset protection entity here, but do you want it to be a flow-through entity or do you want it to be an old C Corp? Well, what works best? Now,
I'm sorry to interrupt you, Bob, but some of my colleagues, they're just going to form the entity they think of, and you're only going to find out about it after the fact as a CPA, and then you got to deal with, oh God, that's not really the tax result we wanted. What are we going to do? So that does happen too, but it's certainly better if everyone would talk ahead of time. Doesn't always happen that way. So, but that is the gold standard of what you want. You want communication.
that's the gold standard. Now, you also want to segregate your risky assets and your safe assets.
Can I interject before we get to that? One of the things that I've seen happen is much, and I don't mean to be disrespectful, so no one take this the wrong way, but a lot of, most if not all financial advisors are getting more and more involved in estate planning. And I've seen amongst many of them, there's a focus on avoiding probate. And I understand that, and that's nothing wrong with it. My wife and I have revocable trusts. I'd have to think hard if we have any assets that are still probate assets, because I do believe in that planning. That being said, before you get the focus on revocable trusts or other techniques like joint ownership to avoid probate, you need to start with what are the real priorities. And for an awful lot of the people that we see, because we as advisors see people with a higher income and higher wealth level than maybe the average American, probate avoidance, okay, it's useful, but protecting assets from creditors is much more important. Probate could cost some money and time and be a hassle, but a creditor can get 100% of what you have. There's no comparison to the potential downside. So for example, I've seen clients get advised to put all their accounts as TOD, transfer on death, pay on death, joint. That's great. So when somebody dies, all the assets go to the surviving spouse or to the kids or whoever. There's no trusts involved. Any asset protection is lost. So keep in mind, it's really a balance of the different competing goals. And this, just like I was kind of saying part in jest, how lawyers sometimes don't let the accountants get involved in the choice of entity and they pick an entity that works for the legal reasons but not for the tax reasons, is the advisors overall, we need to coordinate and understand the big picture, not get focused on something like just probate avoidance and harm the client in the process. And these are all things that as a CPA, you'll hear about and you can have involvement in and should.
Well, absolutely, Marty. And then, on the advanced side, asset protection trusts in the U.S., foreign asset protection trusts, that is really, from my perspective, the CPA just refers that to the lawyer and gets out of the way. And then entity layering, a lot of tax structuring has to go into that. How do we move the pieces around the chessboard without triggering tax? So Marty, that's kind of a lay of the land on from low cost, high impact steps all the way through the more advanced measures. And the other thing that I have a lot of my clients do, it's small, and I encourage the people at the CPA firm with me, is they should all be doing non-deductible IRAs each year. In most states, your IRA is protected. So if husband and wife can put away an extra $15,000, $20,000 a year and protect it, that only makes sense.
I've done that personally for as long as I can remember. And I also convert to Roth because if I can use non-protected assets, cash in the bank, in my revocable trust, to pay the income tax, and now I have dollar for dollar protection as opposed to pre-tax dollars. So I enhance what's protected by doing the Roth conversion. I've been told by people that it's a mistake to make the non-deductible IRA, but the reason I've done it, it's fully protected under state law for me, and it's a small pot. It's only so much you can put in each year. So why would a creditor ever even want to try to pierce that pot? So it gives me the comfort of knowing I got another pot. One of the trite sounding, but I think important aspects of asset protection was what my mom always told me. I don't know if your mom told you the same thing. Don't put all your eggs in
one basket.
one basket. So if you have a Roth IRA and you have a non-deductible IRA and you have irrevocable slats and you have an insurance trust, why do I need an insurance trust? I can do it in a slat because now I got another bucket. Claimants are going to have to pierce through all those buckets. It's going to be time consuming and costly. If you take those buckets and once they pierce it, they now have an LLC that's fractionally owned by different trusts. They still haven't gotten to the gold, if you will. And if you have trusts in different jurisdictions, one in Alaska, one in Nevada, one in your home state, it gets more and more costly and difficult and complicated for a claimant to even understand what's going on. And the other piece, and this is where you as a CPA can play a valuable role, and you can help the attorney that's doing this planning, so you should remain involved, is the following. Why'd you set up that trust, defendant? I set up an insurance trust. I have young kids and I wanted life insurance. Oh, okay, that makes sense. That's a non-asset protection motive. Why did you set up all these LLCs? Because my CPA, Bob Keebler, recommended that it makes sense to have separate LLCs for each entity each property that I own. Okay, that's a reasonable purpose for doing it. It wasn't just you put the assets and adapt. And why did you put in 48% of each LLC, Mr. Defendant, into your trust and 48% into your spouse's trust? Well, because my accountant advised me that I could qualify for discounts for estate planning purposes. Now, with a lot of clients with an exemption of 15 million, that doesn't work. But for most of our history, and still for a lot of wealthier clients, discounts and other plannings are non-asset protection motives. To the extent you can explain, yes, I converted this IRA because my accountant explained to me that converting to a Roth is a good tax advantage. Okay, so it wasn't just asset protection motivated. So getting a real story for every move and step made, I think, is making it more defensible later when it comes up. Let me, Bob, take a second and connect what I highlighted in yellow in terms of entity and trust hygiene and the entity layering and things below. And I want to also go back to your comment about multiple entities for different properties and different operating businesses. One of the problems that clients have with all this, oh my gosh, this is really getting complicated. But you as the CPA can be a key, if not the key advisor, helping administer the plan. If you're doing a tax return for each entity and you're advising the client on what to do in terms of where to pay expenses, how to allocate expenses, you have your arms around the details of their whole plan. Clients shouldn't have to get put off by the complexity of a plan if there's logic for doing it. If you can assure them that your team, and some of it may even be lower level staff just helping do bill pay, but if your team can help them deal properly with the administration of the plan, you're safeguarding the whole plan, but you're also making it more feasible for a client to accept a good plan because you can take on the burden of some of the complexity so they don't have to. Thoughts on that, Bob?
I think that's right, because clients want to run their business, Marty. And if their lawyer or CPA,
they don't want to deal with this stuff.
They don't want to deal with this stuff.
Not
and
at
a
all.
lawyer or CPA can take some of this weight off them and do it efficiently. That's a good thing.
So, Bob, let me tell you, apropos to some comments you made earlier, what I've done with my CPA is I make sure that my CPA bills an amount for income tax prep to every irrevocable trust and even revocable trust that I have, because I feel that's one way to demonstrate that I'm respecting the independence of each trust, which I think is important from an asset protection standpoint. Bob, any thoughts on that?
Well, I think that's right. If you're paying those bills, you're arguably every time you pay a bill making another transfer into that trust. So, Marty, if you set up a trust 15 years ago and haven't put any more money into it, hard to attribute any bad motives on some car accident that happened yesterday.
No, but you're right. Then that's a great example of a simple trust hygiene that is often violated. And that's probably the most common one. Trustees, professional trustees, institutional trustees often send a bill to the client because I think they're under some state laws they're required to the settlor or something. And I have clients pay it directly. They can't. That's another gift. It should require a gift tax return with GST allocation. it shouldn't be what they do. The trust should pay it. But if you have the trust pay the trustee fee directly, pay the accountant for the income tax return directly, there may be nothing else involved in the trust. But if you're paying those personally, it just doesn't demonstrate the independence of the trust the way I would prefer to see you do it. So simple little things that an accountant can identify and address with the client can really help add credibility to showing the respect for the plan. And I think that's really important.
Yeah, absolutely.
Let me talk for a minute about the CES trust for a second. So there was a case in Delaware not so long ago. It had that funny name, CES 2007 Trust. And the client had created this asset protection trust. It's a DAPT, D-A-P-T, a domestic asset protection trust. The client themselves, the settler, was a beneficiary. And that type of trust is permissible now in over 20 states. It started with Alaska alone, and I think 1998 may have been the first year. And it's grown to well over 20 states now permit these types of trusts. There's still some uncertainty, though we don't know how to measure it, that if you're in a state like New York or California that don't permit self-settled trusts and you create one in South Dakota, which does that work? But there's no case saying it didn't. The individual in the CES trust was living in Michigan before Michigan had a self-settled trust statute and transferred assets into the trust, was later sued. And the court in Delaware said the trust is qualified as a domestic asset protection trust and can't be pierced. The client in the case didn't do a great job on trust hygiene. There were issues with not paying the trustee and changing trustees and having LLCs in the trust where there may have been some personal expenses and transfers back and forth. Those kind of things, you'll know just by the smell test whether or not they really make sense, and they don't. You can't put an asset in a trust and take it out a week later. You can't put an asset in trust and borrow money personally from it unless the LLC borrows the money, gives it to the trust, and the trust has permission under the trust document to loan it to the individual. Without reading the trust document, you know transactions like that need to be looked at, and you can alert somebody to it. But they didn't have great trust hygiene, but nonetheless, they won the case in Delaware. Sometime later, the same settler client was sued in Colorado because they had transferred land or an LLC to the trust for $10, which was really a funding, and they were at the time under a court order not to make any non-business transfers because there was a claim against them. So that was unwound, but the trust itself was respected. But that case was worrisome from the standpoint that even though the taxpayer won, the settler won, they could have done a much better job in trust hygiene. And that's where your role is so important, because the separate final transfer they made was unwound. So keep on top of what clients are doing. Try to be the first person they talk to so that you can help make sure things make sense, and reach out to their lawyer. Tell the client, I got to speak to your lawyer and see how to do this. But you can really have an incredibly valuable role in helping these clients maintain the integrity of whatever plan. And by the way, Bob, to be fair to the practitioners, if you're going to help maintain a plan, you got to know what the plan is. Let me tell you what we try to do. We create schematics for any plan that's got more than a handful of moving parts so that it's easy visually to see it. And if you have a schematic, whether it's 1 page or 10 pages, but if you have a fairly simplified schematic that lists the correct legal name of each trust and entity and shows you who owns what and where, that visual can be invaluable to your helping maintain trust and entity hygiene. The other thing we do is we create an electronic closing binder with a table of contents so that you get every single document that was relevant to this plan. And we do that because it's really not that expensive to do it while you're doing the plan. If somebody comes back years later and you got to find all the documents that different professionals did, and most of which you never got copies of, it can be very costly to do. But getting all the documents organized, you now have a permanent file from the lawyer of every key document. So if you want to look something up or check a name, you have it. If you're doing a gift tax return, that you have every document you want for an exhibit to meet adequate disclosure. You have to be proactive to help educate the client that you need a schematic of a plan, you need the governing documents, And from my perspective as a lawyer, it's a lot cheaper, simpler, and better to do it while the plan is being formulated than to have to go back and reconstruct it. Any thoughts or comments on that, Bob?
I think that's fair, Marty, and it's just so important. I've worked with you on many cases, and you and Steve Oceans does the same thing, and so does Kristen Simmons, Heidi Freeman. You guys write this wonderful letter or memo just to spell out what I'm supposed to do. Bob, we created 4 trusts. These 2 are GST exempt. These 2 are non-exempt. These are grantor trusts. These are non-grantor trusts. These were the gifts into the trust. You make it very easy for the CPAs to do their work.
That should be the norm, and it truly isn't. Because when we get a new client in, we spend often just a huge amount of time just trying to figure out what they have going on, because a lot of clients can't explain what's going on. They never got an organized pack of documents, and I don't know how their CPA could possibly know what to file if it takes us, days of time just to figure out what they have. So as a CPA, if you're given a return, you should really ask the first go round, I need a copy of the governing trust document. I'd like to know what the plan is. If I'm doing a gift tax return, can somebody lay out what it is? And if I'm the attorney that did it, whoever the attorney is that did it, it's much cheaper, easier, more efficient for the attorney who created the plan to put things together for you than for you to have to figure it out blindly. Bob, I think we have about 5 more minutes. Does that sound right, or did I mistime us?
No, that's fine.
You want to talk a little bit about the different types of trust structures that you feel CPA should, I don't think we need to get into too much detail, but just to lay out some of the thoughts about different types of trust structures.
Sure. You have to ask yourself, is the trust a grantor trust where the income's reported back on my return, or is it a non-grantor trust that pays its own taxes? Then the second question, I guess the first question is, do you have a revocable or irrevocable trust? The second question is it a grantor or non-grantor? And then very nuanced, Marty, but in some states like South Dakota and Nevada, a sophisticated lawyer can draft a trust to be, in Nevada, they call them NINGs, N-I-N-G, where the gift is incomplete. There's no gift for federal gift tax purposes, but yet you do create asset protection by doing that. And it's very important to understand that, because you want the gift tax returns to match up with what the lawyer intended the structure to be.
And the income tax returns.
And the income tax returns. And that's just very important. Now, the other thing is, there's a case which you and I have taught about called Sel Medino. Sel Medino, it turns out that the husband's property went to his wife, and then it got into a trust for the husband, but it was really just a gift
for the husband's kids from a prior marriage.
And we need to make sure we understand how things move between spouses and the legitimate transfers. And that's so, because in a community property state, Marty, if I think I'm doing the right thing, I'm putting property in a trust for my wife, children, and grandchildren. Except, Marty, Wisconsin has marital property. So I put $100 in there, 50's for my wife and 50's for me.
You got a self-settled trust.
We have a self-settled trust with regard to my wife. And the lawyer should be looking for that and making sure it doesn't happen. But if it does happen, a great diving catch by the CPA is to go back and say, wait a minute, what do we do here? Is this right?
You can sever the community property by a transmutation agreement and then have it be able to be divided. Now, I've actually had discussions with lawyers in community property states about this, where they would do one document and take community property, transmute it into separate property, and all have it end up in the husband's name so he could fund a slat for the wife. And I said, I don't like that. And I don't even care if you tell me it absolutely works under your state law. if we're going to sever it, I want half in wife's name, half in husband's name. I want to leave it there for a while before the wife makes a gift to the husband. And then I want to leave it there a longer while before the husband puts it in a trust for the wife. You got step transaction issues, like the Smaldino case that Bob mentioned. And you got to be careful with that. And I find that a lot of advisors, including lawyers sometimes, get very loose, lax about transfers between spouses. You have to be careful because if husband is worried about lawsuits and he just moves assets to wife and then she moves them into a trust, the Smaldino kind of argument of step transaction could unwind the whole asset protection plan. And while I would hope that most attorneys are aware of it, a lot of general practice or attorneys that don't specialize in this may not be. So you may be the most important safeguard the client has to pick up on some of this stuff.
I think that's right. And, you've talked about no personal expenses from trust or LLC accounts.
Unless it's permitted.
Unless it's permitted.
Like as a beneficiary. If your wife is a beneficiary of a trust you created for her, she can get expenses paid, but I'd still be careful because you don't want to have something look like an implied agreement, like every expense is being paid. You don't want it done every single week. You want it, more sporadic so it doesn't look like there's an implied agreement.
Well, absolutely. So do we have one more slide, Marty?
Yeah, I have one last thing I want to talk about, which is on this slide that's important. So here's and I maybe we should have started with this, but here's a role, a purpose, asset protection planning purpose that you as a CPA can serve, and I think do a phenomenal job of. Identifying issues, even if you don't have all the planning answers, without identifying an issue and alerting the client to it and getting them to the right people to address it, nothing's going to ever get done right. You know what a balance sheet is better than any other advisor. If you get a good detailed balance sheet for the family unit, however that's defined, could be a single individual, could be a married couple, there may be irrevocable trusts. I want to see those as separate columns. And you list down balance sheet items. And I don't want to know that they have 5 different brokerage accounts that have marketable securities. You can list it as one account. I'm looking for the nature of the assets. You then go line by line through the balance sheet you put together. And this is going to be a different kind of balance sheet perhaps than the financial advisor may put together or that a lawyer may put together for estate planning. It's got some things more detailed, other things aggregated because you're looking for the big picture issues. Go line by line through it. And some of the things that we've already talked about, a lot of the things you're going to identify here. So for example, okay, there's a rental property. There's not one, but 2 issues to look at. Bob talked about one very clearly. If the client owns a rental property and it's not in an entity, have them talk to an attorney and get it into an entity. And you have to be careful. I wouldn't even transfer a rental property. Have real estate counsel do it because what if there's a due on transfer clause in the mortgage or a due on transfer clause in a lease, or what if there's local transfer taxes that could be costly? You got to be careful. But the first issue is what liability can that asset or activity create for the client? Rental property, somebody gets hurt, they sue and try to get personal assets. So you want it into an entity. And it's not just assets, and that's why I said this is a different kind of balance sheet that you know how to assemble because you know what the client's involved in. It also includes activities. The client may have a home-based business where they're doing woodworking with, potentially dangerous or flammable equipment. Well, that creates a liability. Maybe that should be in an entity, even though there's really not a lot of valuable assets or income. Think about the liability that each item in that list on the balance sheet can create for the client as a whole. But there's a second aspect to it. So if I put the rental property, a valuable rental property, into an LLC, maybe as long as the formalities are met and so on, there's no fraudulent conveyance, I'm protecting the client's home and other personal assets because if there's a claim against the rental property, it should be limited to reaching only that asset. But similarly, how do I protect that asset? So in other words, if a client has a multi-million-dollar rental property, you put it in an LLC, that protects the client personally, but that multi-million-dollar rental property in a single member LLC may still be exposed. Maybe husband gives half to wife. Maybe husband takes his half and puts it into an irrevocable dynastic trust. So now you have two different owners, and you fractionalize the ownership. So if somebody sues the wife or the husband doesn't own anything, it's in a trust. The wife owns only half, it's hard to seize on it. And maybe the next year, the wife will create a different trust and make a gift transfer to that. So you have to look at every single, not just asset, but activity. Kids driving a car, that's an activity. Maybe the parents shouldn't own the car. Rental property, you look at the asset and how to protect the asset, how to protect the person from the risk of the asset, and how to protect both. If you do that kind of logical analysis, and everything that I've just said, I think is common sense to most CPAs, you can identify the issues, whether or not you know the answers. And some of the answers you're going to know, just like we talked about. But that is how to really engage the client in evaluating and understanding what they can do to protect their assets. Bob, I think we're almost out of time. I'm going to let you wrap up, and hopefully this has been practical and helpful to our CPA audience and any others that wanted to hear us talk.
So Marty, I think you're right. Put together a balance sheet, and then you have to ask yourself, what inside risks do I have that become outside risks? In other words, if an entity is pierced, or if there's just too much inside a corp or an LLC, and then you have to ask yourself, are there outside risks like driving my car that I need to do a better job protecting? Now, you do bring up all of these international multi-state high net worth considerations. If somebody is creating a foreign asset protection trust, you definitely, if you're a CPA, you definitely want to get help from a CPA that specializes on these international issues. You have FBAR and FATCA things going on. You have all kinds of withholding when money goes back and forth. The trust is probably a grantor trust, Marty. Now, the interesting thing about multi-state trusts is many people create non-grantor trusts in Alaska, Delaware, Nevada to save state income tax. It's something that happens all the time for people in New York and California.
Just be careful in New York or California, as you know, but I don't know if everyone on the call knows that you have to have a completed gift non-grantor trust, because New York and California won't respect that. I'm sorry if you were going to say that. I just want to make sure we got that in.
I wasn't going to say that, but let me just expand on that. If we create a NING, New York resident creates a NING in Nevada, New York is going to tax that. Now, if it's a completed gift, they will not. And California has the same rule. So, sure, this stuff is complex, but you can't be afraid to get into it, and you need to be working with the right lawyers who will, quite frankly, for the first couple of cases, take you by the hand and walk you through it.
And you should ask for that.
You should
There's
ask.
nothing wrong with that.
Now, I think the international, again, get help, very tricky. These domestic asset protection trusts, you really want to make sure the client's respecting these. Now, the other thing, Marty, is you taught me this. If I create a DAP, it's a perfectly well-drafted DAP, but every week I take $5,000 out, like clockwork. That's a disaster, okay? You would want, if I created a domestic asset protection trust, I would tell the client, let's not touch it for 2, 3, 4, 5 years. Let's just, so that when you testify or the trustee testifies, did Mr. Shenkman take any money out of the trust from the 2015 through 2026? No, not a penny. Wow, that's a lot different answer than, well, yeah, he took out $5,000 a week. every Friday at 1:37.
Yeah,
I
it
mean,
may be obvious to you as a practitioner that somebody withdrawing money from an irrevocable trust, even monthly, starts to look like a pattern and implied agreement, but it's not going to be obvious to a lot of our clients. It's my trust, it's my money. No, it's not your money. You gave it to a trust. A lot of and this is why your role as a CPA is so important to protecting every asset protection plan and implementing it. Things that are obvious to you, just common sense, CPA common sense, let me call it that, are not client common sense. And that one role is huge of value
that's
to the clients.
that's absolutely critical. The other thing, Marty, that as a CPA, what our listeners can do is, let's say I'm worth $25 million, but my wife and I only spend $200,000 a year. Your first observation is, Bob, if you buried it all in the backyard, you guys could go 125 years and not without earning a penny. So, and how long are you going to live? I mean, maybe best case scenario, 30 years, 35 years. We can put that 35 years over here in your left hand, but we can move the other 2/3 of what you have into these structures to give you asset protection so that you'll have something definitely to pass downstream to your family. And it depends on what the risk is, Marty. If the risk is me driving my car, I'm a 70-year-old retired school superintendent, my risk is driving my car or hitting a golf ball, right?
How
That
bad of a golfer are you, Bob?
pretty bad. But we can insure that, right?
Yeah.
On the other hand, if the risk is malpractice or I have all kinds of apartment buildings,
Unlimited.
then the unlimited, we don't know where the next storm is going to come from.
Again, we have to wrap up, but I think the concept you just talked about is exactly what you as a CPA should do with the client. Here's what you're spending, so here's what you need. Some portion of what you have, and you may not be comfortable giving it, all that portion away, but let's start with half of that portion. Let's put some piece of this into a protective structure so you have money for that rainy day if something bad happens, and you've left plenty of money to support your lifestyle and then some in your name. Doing that discussion, doing that analysis is the foundation of asset protection planning. And if you go over that, where you've put so much into a so-called protective structure that you can't really afford your lifestyle expenses, it's not going to work. And by the way, from a psychological perspective, it's always easier for a client to take small steps than to, oh my gosh, give away a huge chunk of their wealth. Get them started. Be the motivation, the catalyst to the plan. Bob, why don't you wrap up and I'll be quiet.
I think there's a world of opportunity here. It dovetails with the estate planning. You want to be, I'm going to use the word hyper collaborative with the lawyer. And depending how well you know the lawyer, if you know the lawyer well, they're not going to worry about what's the unauthorized practice of law. And certainly if you're in the room with the lawyer, you defer to the lawyer on things that are pure federal or state law that have no tax implications. If it's a lawyer you do not know well, tread carefully. Let them take the lead on some of this so that they feel comfortable with your role. But there's so much opportunity here, and you owe it to your high net worth clients to at least raise these issues. What would happen, if you have 20 apartment buildings in one LLC, what would happen in a worst case scenario, Marty? You're going to lose
everything.
All 20 buildings, where if we isolate those, you're going to lose one building.
But again, if you as the CPA can say, listen, client, it's going to be a pain in the neck. You're going to have all these annual reports. You're going to have all these tax returns. We're going to honcho it for you. Do what's safe for you to protect the wealth that you've amassed. We'll take the burden, as much of it as we can.
I think that's the message. The CPA can pick up a lot of the hard work. Let the client do what they do best.
One last thing in closing, let's think of the financial advisors. When there's a plan going on like this, Bob rattled off grantor trust, non-grantor trust, different jurisdictions, different types of entities. Where you may have investment assets, it's important that you have a meeting with the wealth advisor, because the asset allocation, call it 50 bonds, 50 stock, may stay the same, but the asset location, which assets are in which buckets, may change dramatically. If you have a non-grantor trust in Nevada, a NING, as Bob talked about, and you live in New York, it's not going to work. You're still subject to New York tax. If you have a completed gift non-grantor trust in Nevada, New York shouldn't tax it. But you want to make sure that you're not having assets that are producing New York situs income, like a partnership interest in there. You may want to have, the growth assets in dynastic trusts. And if there's a trust where there's going to be a periodic payment out, maybe you have the income assets there. If you're doing Roth conversions, all these things can have an impact. Talk to the investment advisor so they understand the new buckets that may affect where they put their asset allocation. Bob, do you have anything else to say, or we'll wrap up?
No, just thank you, Marty. It's always an honor to present with you.
Thank you, Bob, and thank you everyone for joining us, and good luck. But don't shy away from asset protection. Just be mindful and careful how far you go. But your role as a CPA is really, really important. And a lot of the really valuable contributions you can make are things that I suspect most CPAs are comfortable with. Don't get put off that you don't know how to draft a domestic asset protection trust. You don't need to, and you shouldn't. But there's an awful lot you can do. And hopefully we've given you some practical ideas. Thank you, everybody.